Hi. Let's learn about the Hart-Scott-Rodino Antitrust Improvements Act of 1976. The Hart-Scott-Rodino Antitrust Improvements Act of 1976 requires large companies to file notifications with the Federal Trade Commission and the Antitrust Division of the Department of Justice before certain mergers and acquisitions or tender offers. For example, if two big companies like McDonald's and Burger King wanted to merge, they would have to file these notifications to the government first. Once companies file the required forms, a waiting period begins. The waiting period is usually 30 days, or 15 days for cash tender offers or an acquisition in bankruptcy. During this period, regulators get a chance to review the proposed merger based on antitrust laws. If regulators see potential anti-competitive issues with the proposed merger, they will request additional information from the companies involved and extend the waiting period. They will negotiate an agreement with the companies to enact measures to restore competition, or they will seek to stop the transaction by filing a preliminary injunction in court. Under the HSR Act, there are specific tests that must be met to require a pre-merger filing. For example, the base filing threshold for the HSR Act in 2020 is $904 million, which determines whether a transaction requires a pre-merger notification. There are also size-of-person thresholds and transaction size tests that apply to all transactions, even if the size-of-person threshold is not met. HSR forms carry a filing fee that varies depending on the size of a transaction. For example, transactions worth more than $94 million but less than $188 million require a $45,000 filing fee. Transactions valued at more than $188 million but less than $940.1 million incur a $125,000 filing fee. The filing fee is $280,000 for transactions greater than $940.1 million. Here are three key takeaways. 1. The Hart-Scott-Rodino Antitrust Improvements Act of 1976 requires companies to file pre-merger notifications with the Federal Trade Commission and the Justice Department for certain acquisitions. 2. The necessity of pre-merger notifications depends on three factors: the nature of the commerce, the size of the parties involved, and the size of the transaction. 3. If regulators see potential anti-competitive issues, they could negotiate concessions with the companies or seek to preliminarily enjoin the transaction. Hope this would help. Thanks for watching.